Okay, we are now live and on the record for our Monday morning civil docket, May 2nd, 2022. Ms. Williamson, what do you have, ma'am?
Good morning, Your Honor. I have F 5192, 21-9.
Okay, in the interest of minor children?
That is correct, Your Honor. I represent Roberto Trevino Jr. Opposing counsel is Hector Bustos. We
Okay.
spoke this morning, Your Honor. I think we might have submitted a Rule 11, but what we are asking is for some additional time. We're trying to work this out. And we thought we were going to have it done, but we were unable to. So if the court would give us 30 to 45 days, we would appreciate it.
Okay, give me one moment. Let me see. Okay, I have June 22nd.
Yes, Your Honor.
And, oh, wait, that's gonna be,
Judge, we do have June the 6th. That'll be for a quick prove-up at 1:30, Your Honor.
yes, okay, June 6th at 1:30. The 22nd, I forgot, is on a Wednesday, and those are for contested only.
Yes, Your Honor, and I will notify Mr. Bustos right now of our reset date then. I have nothing further before this honorable court, if I could be excused.
Yes, you may. Thank you.
Thank you, Your Honor.
Okay, Mr. Quintanilla, what do you have, sir?
Your Honor, good morning. I have, I believe it's number 17 on your court's docket, Judge, CL 20-2058I.
Okay, Martin Carrion versus Juana Vasquez.
Yes, Your Honor. I represent Ms. Vasquez, Your Honor.
Judge Reno Gonzalez here for Mr. Carrion, Your Honor. Good morning.
Okay, good morning. And what is the announcement, gentlemen?
Your Honor, we're scheduling depositions of the parties, Judge. I believe May 25th is one date that we agreed to. So that's where we're heading, Judge.
That is correct, Your Honor. The case is progressing, Your Honor, and we would ask the court for some time to take care of that. And I think we've also thrown some numbers back and forth.
Okay, and how much time do you need in order to have a good update?
I would say, Your Honor, at least on my part, maybe about 45 days, more or less.
Judge, I would request 60, Your Honor. I think I'm going to be out the first couple of weeks of June, Judge. So I think that's where it's going to fall. But 60 days would be fine.
Okay, why don't we come back? I mean, let's be realistic regarding the summer schedule, right? So
Yeah.
let's get, so we'll be realistic about that. So why don't we come back on August the 8th? And that's on a Monday
Yes, Your Honor.
at 9:30.
Yes, ma'am.
Yes, Judge.
Okay,
Honor.
yes.
I apologize, Judge. It's going to be August the 15th, Judge.
Oh, the 15th? Okay.
Yeah.
Okay.
Oh, right, I forgot I had the CLE. Okay, all right, then we'll see you on August the 15th, gentlemen.
Thank you, Your Honor. Have a wonderful.
Okay, thank you, y'all have a good one.
Be safe. Thank you, Judge.
Likewise. Okay, Mr. Salinas, what do you have, sir?
Yes, good morning, Honor. I have number 23 on page 4 of your docket, Your Honor. The Ozuna divorce, Your Honor.
Okay,
I would-
F 5397-19-9, okay?
Yes, Your Honor. And I set it for status, Your Honor. We have not, I had done for temporary orders, but you were asking if I could get from County Court 2 from the court reporter. He never replied anything back, Your Honor. So I'm asking if we can get a final date, Your Honor, so we can, it's gonna be contested.
Okay, what I'm gonna do is I'm gonna wait for, if you wanna contact Mr. Munoz, because I do need to speak to both of you on that case.
Okay, Your Honor.
So I'm gonna wait, if you wanna contact Mr. Munoz, or I'll have my staff contact Mr. Munoz and let him know that I do need to speak to both of you on this case before we move any further. So if you wanna be on standby, that's perfectly fine with me.
Thank you, Your Honor. If you also, let me try to reach him if your office could reach also Mr. Munoz too. Appreciate that.
Yes, okay. Thank you, sir. Okay, Mr. Sabo, what do you have, Mr. Sabo?
Judge, I've got number 20 on the docket. I don't have the cause number. I just have the docket number.
Okay, that's fine. CL 21-1790-I, Sarah, S-A-R-A, Adame Nájera, N-A-J-E-R-A versus Jessica Medina et al.
And Chris Sanchez, I see him here on the screen, has the plaintiff on this one.
Good morning, Judge. I represent Sarah Adam Nahira.
Okay, good morning, gentlemen. What is the announcement?
I think we're ready to either talk about trying to get this settled, or if that fails, set depositions and then set it for mediation. Mr. Sanchez just filed a motion to compel mediation, which is completely unnecessary. We obviously will agree to mediate if we can't get it settled informally, and I actually have dates already available to mediate if he's interested. So I don't have any problem with that. If we can't get it done informally, we'll take depots and mediate.
Judge, I spoke to Mr. Sable this morning, and I do believe that this matter can very easily be settled, considering that we were not too far apart prior to filing the petition. Now, the petition has been on file for about 1 year. July 6th, 2021, we filed a motion for DCC. This morning, we're respectfully requesting that a docket control conference be set so that we can at least eventually get a trial date. But again, I do believe that this matter, if both sides are willing to mediate and negotiate informally, that we could probably get this one done by Friday.
Great. We'll talk.
That's very eager. Okay, that's fine. The thing is that where are you all on the discovery process? Do you have everything you need in order to make an informed decision for
I
settlement?
think so. I think so.
I think so as well,
All
too.
right. Okay, and so then, and if not, you'll do depositions and then mediation. So before we jump to a DCC, then what I'm gonna do, I'm gonna give you plenty of time to be able to get all of this worked out. If you really do get it worked out very fast, let us know. And if you need us, for a hearing to get it resolved, that's fine. Other than that, then I'm gonna set you for August the 15th at 9:30. That's more than enough according to the timeline that you have. So if you all finish up, then go ahead and call us and then we'll get you set sooner.
Perfect.
Thank you, Your Honor. That's all I have. Can I be excused?
You certainly may.
Me too.
Thank you.
Oh,
Mr.
Judge-
David. Oh,
Judge,
yeah.
I failed to, in one of my friend duties, to make an announcement, if you'll indulge me for just 5 seconds.
Oh, sure. Okay.
For everyone on this Zoom, the deadline to vote in the state bar election is today. My very good friend and a friend of all of us, Joe Escobedo, is one of the candidates for state bar president. It takes 30 seconds to vote. If you haven't voted already, today is the deadline. They'll be announcing the results later today. So please vote. That was it. Thanks, Judge.
Okay. That's today's PSA.
Yep.
All right. No problem, Mr. Sabo. Okay, Mr. Davis, what do you have?
Good morning, Judge. It's number 10 on your docket, F05902229.
Yes, in the matter of the merit of Eric Chavez, ERICK, and Perla Reyes.
Yes, ma'am, Judge. I represent the petitioner. It's our motion for substituted service. This is a case where there's no minor children, no children at all. They've been separated for 15 years, so there's no jointly owned property. The only property they have is what's in their respective possessions. So we're under 6409. We were asking permission from the court to go ahead and do the citation by posting, and for the court to also order that we not have to have an attorney ad litem for the case.
Okay, and so there's nothing involved in this then?
Yes, ma'am. They've been apart for over 15 years.
Okay, and Mr. Chavez's knowledge is that the last place that he knows where Ms. Reyes is was here in this county?
Yes, they lived together here in 2007.
Okay, all right. Then the court is taking judicial notice of the documents in the court's file and is granting your motion for substituted service. And because they have no community property and no children, no ad litem will be appointed.
Thank you, Judge. That's all I have. Maybe excused.
You certainly may.
Thank you.
Thank you. Mr. Brew, what do you have, ma'am?
Yes, Your Honor. I'm not sure the number on the docket, but the case number is CL 20-0862-I.
Okay.
Number 16.
Number 16. All right, Luis Sustaita, Sustaita Jr. versus Felicia Rivera et al.
Yes, Heather Abreu for the plaintiff, Your Honor. This matter has settled. We are just waiting to receive the settlement check, and then we'll be entering the non-suit.
Okay, great. Mr. Denzer, anything to add?
Same announcement, Judge. Nick Denzer for the defendant. We're closing it out. We should be done in the next week or two.
Okay, then I'll go ahead and just set a tickler for the 27th, just to make sure that everything's been submitted.
Sounds good, Your Honor.
Okay, anything else, Ms. Abreu?
Nothing else, if I may be
Okay.
excused. Thank you.
Yes, ma'am. Mr. Denzer, anything else?
That's it, Judge. Thank you very much.
Okay, have a good day.
You too.
Mr. Cabrera, what do you have, sir?
Morning, Your Honor. I have number 19 on your docket. It is CL 21-04691, Discover versus Rita Span. I represent Discover. We're just trying to get a trial date set.
Okay,
I'm fine with sometime in August if possible.
and this will be, give me one moment. Okay, so she did file an answer, a motion for summary judgment was filed. You also filed an order setting hearing on bench trial. And then we set you up on the 31st of this past January.
That's correct, Your Honor. And
Okay.
we were trying to get this settled, but I just feel like let's try to set it for trial again. And I'm fine sometime in August. Maybe it'll give us more time to try to settle.
Okay, go ahead and file an order resetting bench trial.
Okay.
And we'll get that set for you. And we'll go ahead and we'll make a notation that you're requesting for an August date.
Okay. Thank you, Your Honor. That's all I had. May I be excused?
You certainly may.
Thank you.
Thank you. Mr. Contreras?
You had a number 21 in your docket. Good
Yes,
morning,
sir.
by the way, Judge.
Good morning, sir. F 2799-21-9 in the matter of the marriage of Kathleen, Kathleen Guerrero versus Adrian Cardosa.
Yes, Judge, we're set for a status this morning, Your Honor. We're almost about to settle this case, Your Honor. We're just asking for another 30 days, Your Honor, because we started informal mediation last week and we're about to settle this week, I believe, Your Honor.
Okay, let Ms. Lopez Singletary make her announcement. Go ahead.
Yes, no
Yes,
problem.
good morning, Judge Lopez Singletary on behalf of Mr. Adrian Cardosa. Judge, I think we have all the agreement of all the terms agreed to, and there might just be one issue, Judge. So Judge Contreras, do you think we can perhaps make an argument and get it done today? I did.
Well, I'm going to send you a proposal this morning, Ms. Singletary, and see if we can agree on that issue, on that one issue. But I
Okay.
think we can resolve it. Maybe we can come back next week with your permission, Judge Ocaña.
If it's agreed to, I can have you all come back on May 16th.
Okay.
That'll work, Judge. I think, yeah, there's just one issue, but everything else was agreed to.
Okay, May 16th at 9:30. If you don't get it worked out, let us know. We'll be glad to go ahead and hear it, and I'll make the decision on that issue.
Thank you so much. Thank you,
Thank
Judge.
you, Your Honor. That's all we have. Can we be excused?
You certainly may.
Thank you, Judge.
Thank you. Y'all have a good day. Ms. Thompson, what do you have, ma'am?
Yes, Judge. Number 4 on the docket.
F 4089-21-9 in the matter of the marriage of Juan Diego Guajardo and Rosalba, Rosalba Guajardo.
Yes, Your Honor. Lucy Thompson here for Mrs. Guajardo, and I don't know if Ms. Guajardo is on because I don't see her name, but I don't know if like Rosa Gamino is her. I'm not sure. But I know that Ms. Gonzalez and her client are on. It would be approved of, Your Honor.
Okay.
Good morning, Judge. Savannah Gonzalez from Mr. Guajardo. He's present in my conference room.
Okay. Let me just, Rosalba Guajardo, are you present?
Yes, I am.
Okay, there she is. And Mr. Guajardo is in your conference room, correct?
Yes, Judge.
Okay. Mr. Guajardo, can you unmute, please?
Sí,
Okay, so he's Spanish speaking?
sí.
Yes, Judge.
Okay, Ms. Castañeda is present. Just go ahead and go slow on the agreement so that she can translate it, okay?
Ms. Thompson, is your client English speaking? Are they both
No.
Spanish? I can't remember.
They're both Spanish.
Okay, thank you so much.
Okay, let me go ahead and have Ms. Castañeda, if you can have them both raise their right hand.
Por favor, levantan los dos la mano derecha.
Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Juran que el testimonio que están a punto de dar es la verdad, toda la verdad y nada más que la verdad.
Sí.
Yes,
And Mr. Guajardo?
yes.
Okay, you may lower your hands. Okay, Ms. Gonzalez, will you be proving it up?
Yes, Judge, I can do so.
Okay, go ahead.
Okay. Mr. Guajardo, you were married to Rosalba Guajardo on or about November of 1994, November 11th?
Sí.
Ah,
Okay, por favor, espere hasta que ya traduzca la Ms. Castañeda, okay? Go ahead, Ms. Castañeda.
señor Guajardo, ¿estaba usted casado con la señora Rosalba Guajardo? Se casó como en noviembre 11 del 94,
20.
the 20th.
Okay. And you stopped living together in September of 2019 approximately, is that correct?
Y dejaron de vivir juntos como en septiembre del 2019, ¿correcto?
Sí.
En mayo.
And although you had children during the marriage, there are no longer any children under the age of 18 or that require support. Is that correct?
Y aunque tuvieron hijos, a este tiempo ya no tienen hijos menores de 18 años que requieren soporte, ¿correcto?
Sí.
Yes.
And as far as you know, your wife is not currently pregnant or expecting a child, correct?
Y como usted sabe ahorita, su esposa no está esperando bebé a este tiempo, ¿correcto?
Sí.
Yes.
And we attended mediation in this case and were able to divide all of the debts and assets of the marriage, correct?
Y atendimos una mediación en este caso y pudimos resolver todos los casos, todos los issues tocante
Debts and assets during the marriage.
los activos que tuvieron durante el matrimonio, ¿correcto?
Sí.
Yes.
And in that mediated settlement agreement, Ms. Rosalba Guajardo is keeping the residence at 1718 Christian Court.
Y durante ese acuerdo mediado que tuvieron, la señora se va a quedar con la residencia en el 1718 Christian Court.
Sí.
Yes.
And she's also keeping her BMW, the 2019, along with any debt associated with that vehicle, correct?
Y también se va a quedar con su automóvil, un BMW 2019, también con la deuda, ¿correcto?
Sí.
Yes.
All right. And you're keeping the 2021 Suburban along with any debt associated with that vehicle.
Y usted se va a quedar con una Suburban 2021 y también se va a quedar con la deuda, ¿correcto?
Sí.
Yes.
You're keeping all of the debt in your name and she's keeping all of the debt in her name, correct?
Y usted se va a quedar con todos, con todos los deudas que tenga su nombre y ella se va a quedar con todas las deudas que están a su nombre, ¿correcto?
Sí.
Yes.
And anything that you have in your possession, you get to keep. Anything she has in her possession, she gets to keep.
Y cualquier cosa que usted tenga en su posición, usted se va a quedar con ellos. Y cualquier cosa que ella tenga en su posición, ella se va a quedar con ellos. ¿Correcto?
Sí, correcto.
Yes. Correct.
And prior to the filing of this suit, had you lived in Texas for at least 6 months and the county of Hidalgo for at least 90 days?
Y antes de meter esta petición, usted vivía en el estado de Texas por los precedentes 6 meses y en el condado de Hidalgo por los precedentes 90 días, ¿correcto?
Sí,
Yes.
And you believe this agreement to be a fair and equitable division of the marital estate?
¿Y usted cree que este acuerdo es justo?
sí,
Yes.
And you're asking the court to approve it and to grant your divorce today, correct?
¿Y usted le está pidiendo a la corte que apruebe este divorcio, correcto?
sí,
Yes.
Okay, and you've reviewed the agreed divorce decree and signed off on that, correct?
Y usted ya revisó, hizo una revisión del decreto y lo firmó, ¿correcto?
sí, correcto.
Yes, correct.
Thank you. Pass the witness, Judge.
Okay, Ms. Thompson, do you have any questions of Mr. Guajardo?
I do not, Your Honor.
Okay, do you have any questions of your client?
Yes, I do, Your Honor.
Okay, you may proceed, ma'am.
Mrs. Guajardo, we attended mediation and we have a signed mediation agreement from April 18th of this year. Is that correct?
Yes.
Señora Guajardo.
Okay, Ms. Guajardo, tell her that she needs to either answer in English or she's gonna have it translated, but she can't do both.
Señora Guajardo, se va a tener que esperar a que yo traduzca o si va a contestar en inglés. No puede hacer las dos.
Ok, traduzca por favor.
Okay. So, tienen un acuerdo firmado de cuando atendieron a la mediación el día 18 de abril, ¿correcto?
Sí,
Yes.
And you heard the agreement that was put on the record by Mrs. Gonzalez. Is that your understanding of the parties' agreement?
Y usted escuchó la declaración que hizo el señor y usted está de acuerdo con esa declaración?
sí,
Yes.
And you believe that it is a just and right division of your assets as well?
¿Y usted cree que esta es una justa y correcta división de su caso?
sí,
Yes.
And you're asking the court to approve this agreement today?
¿Y usted le está pidiendo a la corte que apruebe este acuerdo?
sí.
Yes.
That's all I have, Your Honor.
Okay, then the court is taking judicial notice of all the documents in the court's file, is granting the divorce today as and the relief as requested and testified to in the record and will be set forth in further detail in a final decree of divorce to be executed by all the parties and the attorneys and submitted by how much time?
Ms. Thompson's office has already filed it. I think they might have done so this morning. I'm not sure if it's been
This
accepted.
morning,
but-
correct.
Okay, it still hasn't been accepted. It's not showing, but if it's already filed, then as soon as it comes through, we'll sign off on it.
Yes, ma'am.
Excellent. Thank you, Judge.
Okay, and I was gonna ask before I let y'all go, is she requesting a name change, Ms. Thompson?
Yes. Ay, perdón, sí.
Okay, Ms. Castañeda, ask her what name is she asking for her name to be changed to?
Ms. Guajardo, ¿qué es el nombre que usted está pidiendo que la corte le cambie?
Viera.
Viera.
Okay, and can that be spelled for the record, please?
Y por favor, lo deletrea.
Es V de Víctor I E R A.
Es V-I-E-R-A.
Okay, is that name change reflected on the divorce decree that was e-filed?
No, Your Honor.
Okay, then I'll go ahead and give y'all an opportunity to amend that. And then, so what I'll do is, since it hasn't been accepted yet, I'll go ahead and have my staff reject it. And so we don't get confused. And then I'll let you all e-file the correct one.
Yes, ma'am.
Okay?
Thank
And if nothing further, you all are excused. Ms.
Thank you,
Castañeda,
Judge.
please let them know that they are excused.
Ok, ya se pueden retirar, señor y señora Guajardo.
Gracias.
Thank you.
Thank you, Judge.
Okay, y'all have a good day. Okay, Mr. Ornelas, what do you have, sir?
Good morning, Your Honor. Number 6 on your docket.
All right, that's, let me see, F 5126-21-9 in the matter of the marriage of Myra, Mayra, Yolanda Lopez versus Hector Hugo Lopez.
Good morning, Your Honor. Javier Ornelas on behalf of the petitioner. Your Honor, the respondent is appearing pro se on his own. And he never signed a waiver and he was never served, Your Honor, but he is present today. And he also signed the agreed final decree of divorce. So we're ready to proceed.
All right, are they English speaking or Spanish speaking?
English, Your Honor.
Okay, let me have both of you raise your right hands. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Mrs. Lopez?
Yes, sir.
Yes, ma'am.
Yes, ma'am.
It's okay. And Mr. Lopez?
Yes, ma'am.
All right, you may lower your hands. Mr. Ornelas, go ahead.
Yes, Your Honor. Is your full name Mayra Yolanda Lopez?
Yes, sir.
And you reside at 3612 North 34th Street in McAllen, Hidalgo County, Texas?
Yes, sir.
You were the one who filed this petition for divorce. Is that correct?
Yes, sir.
Before you filed this petition for divorce, were you a domiciliary in the state of Texas for at least 6 months?
Yes, sir.
Were you a resident of this county of Hidalgo for 90 days?
Yes, sir.
Are you telling this court that you were married on December 30th, 1990?
Yes, sir.
You separated as husband and wife on or about April the 1st, 2017.
Yes, sir.
The reason for your separation was because there was a discord or conflict of characters or personalities between you and your spouse. Is that correct?
Yes, sir.
This destroyed the marriage relationship?
Yes, sir.
Is there any chance of you all getting back together, of reconciliation?
No.
All of your children are adults, is that correct?
Yes, sir.
And you have no minor children that you have biologically or adopted, is that correct?
Yes, sir.
And you're not expecting child at this time, is that correct?
Yes, sir.
Have you and your husband entered into an agreement concerning the division of the marital estate?
Yes, sir.
And you have signed a document entitled Agreed Final Decree of Divorce, is that correct?
Yes, sir.
And in that final decree of divorce, it states that you will be awarded the residence where you live in right now as your sole and separate property. Is that correct?
Yes, sir.
That is described as Lot 51, Ponderosa Park, Phase 5 in McAllen, correct?
Yes, sir.
You will be keeping all the personal property and furniture and appliances that you have in that house. Is that correct?
Yes, sir.
You'll be keeping all your clothes and jewelry and personal effects that you have in your possession. Is that correct?
Yes, sir.
You'll be keeping all sums of cash that you have in your possession and any money that you have in any bank account in your name.
Yes, sir.
As far as the retirement is concerned, you'll be keeping your retirement with TRS.
Yes, sir.
In addition, there is a Merrill Lynch account that you'll be keeping as your sole and separate property. Is that correct?
Yes, sir.
Your husband will be keeping his retirement. However, you'll be keeping $15,000 out of his retirement account. Is that correct?
Yes, sir.
You'll also be keeping your 2014 Jeep Patriot as your sole and separate property.
Yes, sir.
The agreement is that your husband will be keeping whatever personal property, appliances that he has in his possession. Is that correct?
Yes, sir.
He'll be keeping whatever clothing, personal effects that he has in his possession, correct?
Yes, sir.
He'll be keeping whatever sums of cash he has in his possession and whatever money he has in any bank account in his name. Is that correct?
Yes, sir.
Now, he'll be keeping his retirement account less the $15,000 that has been awarded to you. Is that correct?
Yes, sir.
All right. As far as the division of the debts, you'll be basically paying any debts that you have in your name to the date of separation. Is that correct?
Yes, sir.
And he'll be paying whatever debts that he has in his name since the date of separation. Is that correct?
Yes, sir.
And you are not asking this court for a name change. Is that correct?
Yes.
You are asking this court for a divorce?
Yes, sir.
I have no further questions of this witness.
Okay, do you have any questions of Mr. Lopez?
Yes, I do, Your Honor.
Okay, go ahead.
Mr. Lopez, could you please state your full name, please?
Hector Hugo Lopez.
And could you give the court your address?
My new address is 1201 Leticia Street, Edinburgh, Texas, 78542.
You heard the testimony given by your wife. Is that correct?
Yes, sir.
Is that your agreement as well?
Yes, sir.
And you signed an agreed final decree of divorce. Is that correct?
Yes, sir.
And you signed that document freely and voluntarily of your own free will. Is that correct?
Yes, sir.
Do you think this division of the marital estate is a just and right division?
Yes, sir.
You're asking the court to approve this agreement?
Yes, sir.
And you're also asking this court to grant this divorce?
Yes, sir.
No further questions, Your Honor.
Okay, then, Mr. Lopez, even though you were not, you didn't sign a waiver, you signed the final decree of divorce. Are you asking this court to accept that as your answer?
Yes, ma'am.
Okay, then the court is granting the divorce and the relief as requested and testified to by the parties on the record that will be set forth in further detail in a final decree of divorce that has been already signed by the parties and Mr. Ornelas. Mr. Ornelas, is that going to be e-filed today?
It was filed back on February the 24th, Your Honor. So you should have it. What we will be e-filing today, Your Honor, will be the quadro, the qualified domestic relations order signed by the parties, so that we can split that that retirement that the respondent
Okay.
has.
So then the decree that was filed back on February the 24th is the one that you want me to sign?
That is correct.
Okay, then I'll ask for that to be sent to my queue. Okay, anything else?
Nothing further, Your Honor.
Okay, wish you the best of luck, okay?
Thank you, Your Honor.
Y'all take
Thanks.
care, God bless.
Thank you.
Okay, Judge Hinojosa, what do you have, sir?
Good morning, Your Honor.
Good morning, sir.
I have cause number F-3571, 13-2. It's in the matter of the marriage of Jose Alberto Vargas and Maria Guadalupe Vargas. It's a very old divorce. It's never been finalized. I was hired to come in and finalize it, Your Honor. I'm making, I filed a motion to substitute counsel so that I can come in and then get a setting so we can finalize it, Your Honor.
Okay. And and you're representing which party, Judge?
I'm representing Mr. Vargas, Jose Alberto Vargas.
Okay. And do you know who's representing now? Who's representing Miss Vargas now? Because Mr. Holabar, I think, is with another firm now.
Let me see, I've got the docket sheet here, Your Honor. If I can have one second.
Okay, I don't think anybody ever substituted for him.
Yeah.
Okay, well, I'll give you an I'm granting your motion for substitution. And then I'll give you an opportunity to get acclimated because I do not know who's representing her. The last I knew was that Mr. Holabar was withdrawing from the cases that he was on because he had joined another firm.
Right.
I don't know if that's still the case or not.
That's what I have, Your Honor.
Okay, so she may be pro se, so I'll give you an opportunity to meet with her. Do you want a status hearing or?
Yeah, that would be perfect, Your Honor.
Okay, let's go ahead and have a status hearing on, is June 6th too soon? Or June 27th, do you want? Let's do June 27th.
Okay, Your Honor.
That way you have an opportunity at least about 60 days. Okay, we'll do June 27th at 9:30 and that'll be via Zoom.
Thank you, Your Honor. I appreciate that.
Okay,
May I be
anything
excused?
else? Yes, sir.
Thank you.
Thank you. Okay, Mr. Cavazos, what do you have, sir?
Good morning, Judge. Jaime Cavazos here, number 22, Judge.
Okay, number 22. F 4816-16-9 in the interest of minor children.
Yes, Judge, I represent Lorena Martinez. I believe she is present, Your Honor.
Okay.
And I believe Mr. Espinosa is also, he's opposing counsel, Judge. I believe he's on Zoom.
Good morning, Judge. Pete Espinosa for Mr. Daniel Bruneda. We have a quick announcement.
Go ahead, gentlemen.
Wait, Judge, we had been ordered by the court for mediation. We have not done mediation. We're asking for a reset, a short reset to allow us some time to do the mediation.
That's correct, Your Honor.
Okay, has it been because of scheduling conflict or resistance?
No resistance on our part. It's probably more scheduling and communication, Judge.
Okay, and who's the mediator in this case?
I believe we had agreed with Mr. Casares, but I don't want to speak for Mr. Espinosa.
Mr. Cáceres is fine, Judge. We have no issue with him.
Okay. All right, so how much time do y'all need to try to get this mediated?
Judge, my client is local. 30 days would be sufficient for us. I would defer to Mr. Espinosa if he needs more time.
I'd say 30 to 45 days, Judge. My client has been in San Antonio area, but with a Zoom mediation, we should be able to resolve it.
Okay, I'm gonna reset today's hearing to June the 6th at 9:30, just to see if y'all made any progress.
Okay, Judge, if we did schedule mediation, can we turn in Rule 11?
Yes.
Thank you, Judge.
Okay, anything
Yes.
else?
That's all I have, Your Honor.
Okay,
Nothing further, Judge.
all right, thank you. Y'all have a good day.
Judge, can Ms. Martinez be excused?
Yes, she may be excused.
Thank you, Judge.
Thank you.
Take care.
Okay, Mr. Ramos, what do you have? Attorney Juan Ramos.
Good morning, Your Honor. I'm here with Mr. Jaime Hernandez. He filed a motion for mediation.
Okay.
Let me get you that docket number, Judge.
It's number 8 on the court's docket, F0727-22-9, in the matter of the marriage of Aaron Gracia versus Stephanie Stepanie Browen, Brouwen.
Good morning, Your Honor.
Okay, Mr. Hernandez?
I'm Hernandez on behalf of Ms. Bruin. But Your Honor, I filed a motion for mediation. I did have a conversation with Mr. Ramos this morning, and we are in agreement to mediate the case with the 30-day deadline with Mr. Roby Flores.
Okay.
I can submit it a Rule 11 if that would be sufficient for the court to memorialize our agreement.
Well, you have
The order I did.
right, you have an order on the motion for mediation, which was filed on April 22nd. I can just have that forwarded, and if I need to amend anything, I'll just do it. It's not a problem. Okay, so within 30 days with Mr. Flores?
Correct.
Yes, Your Honor.
Okay, and what are the issues in this matter?
Your Honor, initially it was some property regarding the retirement. However, I think we may be able to resolve that prior to mediation. So I do want to just have that deadline, just so that in the event we cannot come to an agreement on it, we'll be set for mediation already and can proceed forward.
Okay, are there children?
There are.
Yes, Your Honor.
There's one.
How old?
There's a 7-year-old, Judge.
So it's one child?
One child, Your Honor.
And
our, sorry, go ahead.
Is the issue custody also?
No, Your Honor, not from our side. Actually, our parties have already been doing exchanges, weekly exchanges. It's more just resolving the property issues, Judge, and that last 10 to 20% to close the gap.
Okay, well, y'all know that I like those cases, so if you can't get it settled, I'll be glad to hear it, okay? All right,
Yes,
so let them know that either they're the ones that get to settle it or I'll settle it. I don't have an issue, okay?
Yes, Your
So
Honor.
it's better for them to have all the control than for me to have the control. Okay,
Yes.
all right,
Yes,
so
Your
I'll go ahead and have that order forwarded to me, and then I'll probably put a status date on there for y'all to come back.
Thank you, Judge.
Okay, anything else, gentlemen?
Nothing further, Judge.
Nothing.
Okay, then you and your clients are excused.
Thank you, Your Honor. You have a wonderful day.
Thank you, likewise. Okay,
Thank you.
Mr. Gutierrez, Attorney Dallas Gutierrez.
Good morning, Your Honor. Dallas Gutierrez standing in for Jesus Villalobos on, this is Patrick Sanchez. It's a family case, Your Honor.
Okay, do you know the number?
It is F-1482-21-9.
Okay, this is set for a DWAP. Are you asking for it to be retained on the docket?
Yes, Your Honor, we are asking for it. We're just asking for it to be retained on the docket. We're just asking for a little more time as well to see if we can, I do think this can be.
You're muted.
Sorry about that, Your Honor. I'm over here going on and on. I do think I have to make sure she's been properly served on this. I just want to double check on that, and then if so, we'll get another hearing to see if to do a default.
Okay, hold on. Well, let's check that. Because we need to be moving on it. And the last time there was no announcement made, that's why it had happened a couple of times. So I set it for a DWAP. All right, let me see. So this was filed. Okay, citation was issued. Okay, so you all filed it back in 2021. Then the AG's office was involved. So let me ask, Ms. Beaver, are you here on this case?
Good morning, Your Honor. No, I am not here on this case. I'm here
Okay.
for 5.
Okay. Let me see. So it doesn't look like she's been served. The only one that was, let me see. No, she had an attorney at the time, didn't she?
I think initially she did, but I don't think she no longer has. I don't think she has an attorney any longer.
Then
And so we're
on-
trying to get her served here.
Okay, on your motion to modify, you did properly serve her through the attorney. And that was back on December 30th, 2021. I'll let you go ahead and look at the docket sheet. But you will need to get with the Attorney General's office because they're all over this docket sheet that they were active on it. Okay, so
Yes,
I'm going to give you an opportunity. I'm going to set you up for a status conference for June the 6th at 9:30. That's via Zoom. So get with the AG's office and see if they're going to continue their involvement in this case. And also check with that young lady to see if she's going to continue representing herself because she doesn't have an attorney right now.
Yes, Your Honor. We will do that.
Okay, all right. Anything else?
We have nothing further, Your Honor. May we be excused?
You certainly may. Thank you. Okay, Mr. Colegio, what do you have, sir?
Good morning, Your Honor. I'm here standing for Ruben Ramirez, number 18 on the court civil docket.
CL 21-0074-I, Jose Quiroz, Quiroz et al. Versus Norma Hernandez.
Yes, Your Honor. Good morning. Robert Coleo for standing for Ruben Ramirez for the defendant.
Selena Padilla from the Padilla Law Firm for plaintiffs.
Okay, and what is the announcement?
Well, Your Honor, we have a mediation set for August 5th with Alfred Denham. That's just a status hearing that the court set.
Okay. And how about, so do you all have everything that you need in order to have a fruitful mediation?
I'm not sure, Your Honor, but I'm sure we can get it by August. I think we're just waiting for discovery if I'm not mistaken.
Okay, Ms. Padilla, any additional announcements?
No, Your Honor. Since the last status hearing, we did have a bit of difficulty getting a hold of our client, but we do believe that we will be able to move forward with mediation and hopefully settle.
All right, then let's go ahead and come back on August the 15th at 9:30 and let's see how it went.
Yes, ma'am. Totally for another status on August 15th?
Yes.
Yes, ma'am.
And that's where you're gonna announce settled. Nah.
Fingers crossed.
Yeah.
Okay, all right.
Thank you. This concludes my
Okay.
business for my excused.
Yes, sir. Anything else, Ms. Padilla?
No, Your Honor. May I be excused as well?
You certainly may. Y'all have a good day.
Yes, ma'am.
Thank you.
Okay, Mr. Guerrero, what do you have, sir?
Judge, I have Victoria Molina. She's at my office. That's a case that we had gotten most of the issues resolved, except the amount of child support that Mr. He goes by the nickname of Silver, but the non-custodial parent gave us some Silvano Molina. I'm not sure if he's online right now. The non-custodial parent gave us some income information so we can calculate the appropriate amount of child support. And we've done that, Judge. I believe the appropriate amount of child support would be $710 a month based on what he shared with us. And that would be the amount we would ask the court to award my client as the final sapture in this case.
Okay, hold on. Okay, so Mr. Molina is representing himself?
Yes, Your Honor. He has decided to represent himself, and he has represented himself through the entirety of this case from start to finish.
Yes.
The only
Okay.
issue that we could not resolve at mediation was the amount of child support. He wanted something as low as, I believe, $300 a month, which didn't make any sense to me without any information. So we did get the information. And I think a fair amount of child support it should be $710. Let me let the court know why I'm saying what I'm saying. He gave us his W-2, not his tax return for 2021. So I'm just gonna presume that this is his only source of income. His gross wages were $51,732.98. He gave us his last two check stubs. He's still with the same employer, except he's working remotely out of Mexico because he's married again, and he has a wife and he lives with his wife in Mexico. And my calculations show he earns a little bit north of $24 an hour. I calculated that based on 2,080 hours of work week, standard work weeks for the whole year. We figured his monthly gross income with that to be $4,166.67, which translated to $698.91. Based on his prior earnings from the prior year, his gross monthly income is $4,311.08, which translates to $722.12 for one child. For two children, I'm sorry. One child. So I figured we get both numbers, divide by 2, it's 710.
Okay, so let me call it Silvano Molina. Are you present? Silvano Molina? Silvano, go ahead.
Judge, in reviewing his email, I did see that it was returned. The email that he provided did not work, Judge.
Okay, do you have an email address for him, Mr. Guerrero?
I would communicate with him through, let me see, I want to say I do have an email address. I know I've emailed this gentleman before. His email, the last email we communicated with it's Silver MIREYA 2029@gmail.com.
I'm sorry, I didn't catch the MI. After MI, I didn't get anything.
Yeah, Silver MIREYA 2029@gmail.com.
Is that different than the one you have?
Yes, ma'am.
Okay.
He had a previous email he would communicate with me through, Judge, which is, maybe that's the one that the court had. It's Silver M999949@gmail.com. And we did have some interaction with that email also.
Okay, I'm just gonna give a brief reset just so that we can get the link sent out to him at the right email address. But it looks like you have everything else done, so I don't have a problem setting you up. It'll be on May the 9th.
May the 9th?
At 9:30. It'll just be a 1-week reset, Ms. Molina, only so that we can make sure that he has the correct link. So he has an opportunity to come on. Doesn't mean he will, but I do have to give him an opportunity.
Okay.
Okay, so we'll see you back then next week.
Thank you, Judge.
All right. Okay, anything else, sir?
Nothing else, Your Honor? May I be excused?
Yes. Hold on, May the 9th, Miss Castañeda, that's a Monday.
Yes, ma'am.
Okay. All right. Okay, Mr. Lifesay, is this on the 11 a.m. one? Or did you have another one, sir? You're on mute, sir.
I apologize, Your Honor. I have one on the 11 o'clock and one on the 9:30. The 9:30 is a status hearing for CL 15-3115-I. And we're trying to be sending out deposition notices, and I'm going to be discussing with the client what he wants to do with this case.
Okay, anyone here on the defense?
Good morning, Judge. Sergio S. Garza for defendant Dimas de Leon.
Good morning, Your Honor. Sonia de Ochoa for the defendant, Jennifer Vargas.
Okay.
And I believe there's another person on.
Yes, good morning, Your Honor. Chris Sully for Fernando Godino and RGV Votech.
Okay. Excellent. All right, so then at this time, you're going to be starting to take depositions?
That's what we intend to, Your Honor.
Okay, any additional announcements?
Your Honor, go ahead.
Thank you. Judge, I have one thing. You signed an order on April 20th, removing the liens and ordering plaintiff Armando Gamboa and South Texas Votech to sign a release of the liens within 7 days. That hasn't been done, Judge. So I wanted to get your attention on that, let you know that we might have to file a motion if it doesn't get filed soon, recorded in the property records soon.
Judge, if I could respond, I haven't seen that order, but be that as it may, I know you did order that. Or you ordered that the liens be removed. What I told opposing counsel was that if he had prepared documents, we would review them, and if they were correct, my client would sign them. The other option, which is what I do in property cases, is you have the order and you take the order is sufficient and you file it in the property records. And I have never had a problem, in the last 20 years with that being effective as for whatever purpose we need it. Usually it's in terms of deeds, but if it's release of liens or whatever, it will work. And so if that needs to be, if he needs to redraft the order so it's effective, that would be fine with us.
And to say something to that, Judge, I did send a copy of the order and I've drafted the releases. I emailed them to opposing counsel, to Mr. Lifesay, on Friday. So that's been done.
Okay, Your Honor, I have not received those. I don't know if they went to spam. I'm not, but I checked them on Friday. I checked the email on Friday afternoon before I left the office, and they weren't there.
I can resend today.
Okay, I'll give you all an opportunity to try to work it out on your own since it's just something so minimal. But if you don't, for whatever reason, of course, you can file any motions that you need for me to hear. Now, on this matter, though, on what we have right now on the status, Mr. Lifesay is announcing that depositions are about to start going underway. I asked for additional announcements, and Ms. De Ochoa, I believe you had one.
Yes, Your Honor. I believe Mr. Lifesay was supposed to amend his petition. I think before, when we're in another court, before it was transferred, he was supposed to amend his petition to be more specific as to which defendants the claims were against, because I know that there is multiple defendants and some of the claims don't apply to some of the defendants. So we were asking for him to amend his petition to be more specific.
I'll do that within 10 days, Your Honor.
Okay. Then what I'm going to do is I'm going to go ahead and give you some time to continue working on this case and see how far y'all can get. And then we'll come back on August the 15th.
Okay, thank you, Your Honor.
At 9:30. Okay.
Thank you, Judge.
Mr. Lifesay, if you'll stay on, Mr. Ruiz is on, and then everyone else on this case is excused.
Thank you, Your Honor.
Okay,
Thank you, Your Honor.
so I understand that, okay, let me go ahead and call CL 173055-I, Mahdi, M-A-H-D-I, Shaheen, S-H-A-H-E-E-N versus South Texas Educational Technologies.
Yes, Keith
That's correct, Your
Lifesay.
Honor.
Go ahead.
Auto Reese for the plaintiff.
Keith Lifesay here for the defendant, Your Honor.
Okay, so gentlemen, I understand that there's a plea to the jurisdiction on file, and I'm sure it's going to be a contested matter. So I wanted to check your schedules for Wednesday morning at 9:30. Would you be available to come in and argue that? If it doesn't work on your schedule, I'm going to work with you because I'm trying to do these contested ones in person. It's been working out a lot better. And since we're transitioning into that, I'm having to do some of these resets off the bench. And I know that can be a little inconveniencing for you all, but if you can't on this Wednesday, let me know and I'll find a date.
I cannot, Your Honor. This Wednesday, I'm unavailable. Sorry, I apologize.
That's fine.
Judge, if I can, this is being as a plea to the jurisdiction, it's just a matter for plaintiff to present enough evidence to show that the court has jurisdiction. And it isn't involve any credibility determinations because that's beyond the scope of the inquiry according to the Supreme Court. So what I was going to suggest is he have a date to file whatever evidence he wants to, and then the court can look at it, and we don't need to bother the court with a hearing or whatever, unless the court thinks it's absolutely necessary. But that's what I think would streamline the process, because if he gets his client on the stand, I can't necessarily cross-examine him and say, well, you worked on this date or you didn't work on this date, or whatever. It's just a question of him making sure he checks every single box he needs to make sure that this court can hear the case.
Well, Mr. Ruiz, do you want to have an opportunity to do that, or do you want arguments?
Your Honor, I want the ability to put on evidence, because when a defendant files a plea to the jurisdiction, it is a trial on jurisdiction. And since 2004, the Texas Supreme Court, in the case of Texas Parks and Wildlife versus Miranda, says that that if you're going to challenge it, you go to trial and you have a hearing. So I'm invoking my client's right to under Miranda and under the Texas Constitution to have a full-blown trial on jurisdiction, because that's what's been called into question. And so there's nothing that says I have to do affidavits. There's nothing that has to, we have a trial. This is a trial court. Let's make sure that we have jurisdiction. I mean, the case has only been around 1,736 days. What's another month, Your Honor?
Judge, if I could respond, I appreciate opposing counsel's enthusiasm, but when he says trial, it's like a summary judgment trial. It's not a trial where you say, where his client says, I've been discriminated against, and my client says, no, he's not been discriminated against. That's not the way it works. It's like a summary judgment. And if he puts on enough evidence, the court has jurisdiction, because under his case and the subsequent case law, it clearly says that a court doesn't have to have a trial to determine whether it has jurisdiction or not. But I mean, it's entirely up to you.
And then the Texas law says the plaintiff or the person who counters the plea to the jurisdiction, a dilatory plea, gets to go and have a hearing. And if the court, because of the pandemic and all this, is making special time for us to go and do this in person, I'm all for it, Your Honor. This is a trial on jurisdiction. If he doesn't want the trial, he can just drop his plea to the jurisdiction. It's that easy. If he doesn't want to go to court, but we're going to court, Your Honor. We want to go to court. We want to do it live and in person, and we get to cross-examine whoever we want.
Judge, I'll do it, whatever. I'm trying to streamline this for the court, and but I can tell Mr. Ruiz right now, I'm not bringing any witnesses, and so there's nobody to get cross-examined. Your client is the person who has to prove that there's jurisdiction.
Once again, Your Honor, he keeps limiting the type of evidence I can present to the court in a plea. I don't know where he gets that authority from. He just spews it off and never cites anything.
Okay, so we're gonna come back on June the 8th at 1:30, and it'll be in person. And whatever it is that you all want to present at that time, you can bring it up at that time.
Your Honor, since we're on the topic of witnesses and stuff, can Mr. Livesay please respond to the initial disclosures? Because I don't want to call him. I don't want to talk to him on the phone. He just.
I believe we already have. I will double check that, but I believe
No,
we
you
already
haven't.
have.
No, you haven't.
Hey. So, okay, look. I understand that we can get frustrated sometimes, but look, we're gonna respect one another as colleagues. So if you're saying that he didn't, Mr. Livesay is saying that he did, then I'm just gonna give y'all an opportunity to look at your files and see if it was done. If it hasn't been done, I'm sure Mr. Livesay will update it. But you know, it's by the rules, so y'all don't have a trial date at this time unless, I don't know, did you all already do a DCC on this?
No, ma'am.
Okay,
No,
so let's do it a step at a time. We're coming on June the 8th at 1:30. And then I expect that if y'all can't talk to each other, then communicate via correspondence so you have a paper trail, okay?
That's fine, Your Honor.
Okay, then we'll see you all on June the 8th at 1:30.
Okay,
thank you.
Okay, y'all have a great day. Okay, Ms. Garza, what do you have, ma'am?
Hi, good morning, Judge. I have number 14 on your docket.
CL 181841-I Midland Funding versus Crystal CRYSTAL Cobos COBOS.
Yes, Your Honor, and this is Cecilia Garza standing in for Veronica Martinez, representing the plaintiff. We've got a default judgment set for this morning. I'm not sure whether Ms. Cobos has appeared or contacted the court.
Okay, I have it set for a status. Let me double check.
Sure. I'm just standing in, so I'll do whatever you tell me.
You're like, I'm gonna preface this by saying, not a problem. Okay, so we are set for a status hearing. Let me see. I believe it was because service was to be perfected, and I don't have any evidence that it was.
Let me
see. Okay, so there was an order for motion for alternative service signed back in 2018. And then I do not see that it was ever served.
So, okay, so then there's, so even if they were served, it hasn't been on file for the requisite 10 days, Judge?
Yes, and I don't even show it being served.
Okay, let me follow up on that and let the client know, and I guess we'll, once service is perfected, I guess we can submit an order setting hearing on the default.
Right, they were supposed to, when they showed up back on January the 31st, that was what we discovered, and their announcement was that between then and now, it would be perfected. But, yeah.
Okay, I apologize for that. Let me see what the delay is, and then, like I said, we'll submit the orders. Are you going to give us another status?
Yes, let me go ahead and give you a status date of August the 15th, and that should give you plenty of time.
It should.
Yes, so if you need something sooner, let us know.
Okay, that's what we'll do, is hopefully we'll shoot for something sooner. So August 15th at 9 o'clock or 10 o'clock?
9:30.
9:30, okay. Thank you, Judge.
Okay, you have anything else?
No, ma'am, may I be excused?
You certainly may, sorry.
See you soon, bye-bye.
Thank you. Okay, Ms. Beaver?
Good morning, Your Honor. Laura Beaver on behalf of the state of Texas. I'm with the Office of the Attorney General's office. And I'm here on number 5 on your docket, and it's a pro se divorce. I believe the Ms. Montes is here. I don't see the non-custodial parent or
Okay.
Mr.
Let me
Pedro.
call F 4543-21-9 in the matter of the marriage of Debbie Montes, Montes versus Pedro Mata. Ms. Montes, can you hear me?
Yes, ma'am.
Okay, so Ms. Beaver, on your part, has everything been done that you need to? Or
Yes.
needs to be taken care of? I'm sorry.
Yes, it has, Your Honor. We would just be taking arrears and in court, I can type upon the order of the court, I can generate that section of the OAG language for Ms. Montes if she needs to incorporate it into her final divorce decree.
Okay, so let me see. Okay, so Mr. Mata, Ms. Rivera, was Mr. Mata given notice of today's hearing?
1 second, Judge, let me double check that. The email that I have, if any. I'm sorry, Judge, I didn't know I was on Zoom, on mute. I sent it to 22 Pedro Mata 22@gmail. And I do know that this email was returned.
Okay.
But that is the email that the clerks have listed for him as well.
Okay, so this was sent to the email address. The notice for today was sent to the email address that he provided to the clerk's office. We don't have any other email address for him, but he filed an answer and I'm just gonna go ahead and move forward with this. So, Ms. Montes.
Yes.
Let me go ahead and have you raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you may lower your hand. So the last time that we were here, it was, you needed to have consolidated this. So this was consolidated into the original case. And so you filed an original petition for divorce. I just had it here. On October 14th, 2021, is that correct?
Yes.
Okay. And you are currently married to Pedro Mata, is that correct?
Yes.
And you, at the time that you filed, you lived in the county for 90 days and in Texas for at least 6 months, is that correct?
Yes.
And you were married on or about August 29th, 2017, and you ceased to live together as husband and wife on October 1st, 2018, is that correct?
Yes.
And you're asking for a divorce today because your marriage has become insupportable due to discord or conflict of personalities that destroys the legitimate ends of the marriage relationship, is that correct?
Yes.
Is there any chance of reconciliation?
No, I mean, we still talk. I still take him the girls over there to Palmview and everything so he can see the girls. And I mean, we still talk as friends. Yeah. But I mean, there's no use for me to still be married to him. And we've been separated for 3 years.
Okay. So you and your husband have 2 daughters, is that correct?
Yes.
And that's Brianna, BRIANAH, Hope Mata, and Ariana, ARIANAH, Faith Mata, is that correct?
Yes.
Okay. And at this time, ma'am, are you expecting a child of this marriage?
No.
Okay.
I can't no more.
Okay. And do you and your husband have any community property together?
No.
Okay. So any debts that you have that are under your name, you will pay, and any debts that he has under his name, he will pay. Is that correct?
Yes.
Okay. And you do not need a name change today. Is that correct?
No, I never changed it.
Okay. So as far as child support is concerned, I'm going to let Ms. Beaver put that information on the record. Ms. Beaver?
Yes, Your Honor, we didn't calculate new child support amounts. I will say that in the case that was consolidated in F 4377-18-2, There was an existing obligation and it was $198 a month. And that began on September 1st, 2021 with a step down to $147. Medical support was set at $57 a month beginning September 1st, 2021 with a CP text care that mother was going to arrange the insurance because they didn't have insurance at a reasonable cost.
Okay, are your children on Medicaid or at this time, Ms. Montes?
They've always had Medicaid.
Okay. And what are the arrears amount, Ms. Bieber?
Yeah, Your Honor, yes, I would offer into evidence what's marked as States Exhibit A, which is a financial activity report, or the court could take judicial notice.
Okay, Ms. Montes, any objection to accepting the exhibit of the financial activity report?
What would that be?
His report where he has not paid child support and what he has paid.
If I
It's
want
on, no. The AG's office is offering it into evidence. Since you're representing yourself, I have to ask you if you have any objection.
Okay. No.
So do you have any objection?
No.
Okay. The court is going to enter the financial activity report into evidence with no objection. Go ahead.
Thank you, Your Honor. And that'll reflect that as of March 31st, 2022, there's an arrears balance, child support arrears balance of $2,636.58. The medical support arrears balance of the same date is $777.26. And we would ask for a payment plan for the child support of $64 a month with a step up to $115 and a final step up to $198. Medical support, we'd ask for a payment plan of $25 a month, and we'd ask that both of them begin June 1st, 2022.
Okay. The court is going to order that the child support continue in the amount of $198 with a step down to $147. Medical support will be $57, and that's to be continued from the previous order. That's the continuing obligation. The court is also going to take the judgment in the amount of $2,636.58 as of March 31st, 2022 in arrears of child support, and the medical support judgment as of March 31st, 2022 will be $777.26. The court further orders that the child support amount will be paid in the amount of $64 with a step up to $115 and then a final step up in the amount of $198. That amount of $64 is to begin on June 1st, 2022. Medical support will be in the amount of $25 per month, also to begin on June 1st, 2022. So the court is granting the relief as requested and testified to on the record by Ms. Montes. And Ms. Montes, the Office of the Attorney General has agreed to assist you in the correct language because your divorce decree that you filed back, way back, is not correct because it needs to reflect the amounts and the judgment that I took today. So if you can please continue to be in contact with Ms. Bieber, and I'm going to give you until May the 27th to turn it in, okay?
To turn in the information or what?
No, to turn in the divorce decree.
Oh, okay. Okay. It's a question, is my husband going to be taken off of child support or no?
No.
Oh, okay. Está bueno. Alrighty.
Okay, so please, does Ms. Bieber, do you have good information on Ms. Montes?
If she could provide her email address, or I will be more confident.
Ms. Montes, can you please provide your email address?
It's montesdebbie7@gmail.com.
Thank you very much. I can email you the language for the section on the arrears today.
Okay.
All right. So then you'll have until May the 27th, okay?
Okay.
All right. Thank you. Thank you, Ms. Bieber, for your assistance.
Thank you, Your Honor. May I be excused?
You certainly may. Okay, Mr. Hinojosa, what do you have?
Judge, good morning, Judge.
Good morning.
I have F-0069-22-9 in the matter of the marriage of Nittler and Amy Nittler and Stephen Nittler and the minor children. We were originally set for the afternoon, but since this case settled at mediation, we were told to ask to basically come in the morning and prove it up.
Yes. Okay, I see that your client is on. And I think, is that Mr. Nittler also on?
I don't see Mr. Nittler.
Okay. All right, Ms. Nittler, can you please unmute yourself? And let me have you raise your right hand now. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, go ahead, Mr. Hinojosa.
Thank you. Your name is Amy Nittler, is that correct?
Yes.
Prior to filing the divorce action, you've been living in the state of Texas for 6 months, is that correct?
Yes.
Prior to filing the divorce action, you live in County Hidalgo at least 90 days, is that correct?
Yes.
And you're asking this court for a divorce, is that correct?
Yes.
There's no expectation that you and Mr. Stephen Nittler are going to reconcile, is that correct?
Yes.
And in the agreement, you settled all issues in a mediated settlement agreement that you signed on April 26th, is that correct?
Yes.
And Mr. Nittler signed it on the day after, April 27th, is that correct? To your knowledge, he signed it after you, is that correct?
Yes.
And in this agreement, you and Mr. Nittler are joint managing conservators, is that correct? You have joint custody.
She froze, Mr. Hinojosa.
Oh, I thought I scared her.
Sorry. Can you hear me?
I can hear you, Ms. Nittler, if you can hear us.
Okay.
It's okay
Yes,
if you
I
want
can.
to.
Thank you. Sorry.
It's okay. Go ahead and turn off your video and it might be a better connection. And I'll just take your testimony.
Thank you, Judge. Ms.
Okay.
Nittler, you and Stephen Nittler are joint management, so you have joint custody, is that correct?
Yes.
And you're the primary custodian. He does think where the kids are going to live at, is that correct?
Yes.
And he'll have standard visitation, but at this time supervised by his parents, is that correct?
Yeah.
Until he completes a alcohol awareness class, a minimum of 6 hours, is that correct?
Yes.
And once he shows you proof of completing of the class, he'll have unsupervised visits, is that correct? Did you hear me, Ms. Nittler?
Yes, correct.
All right, thank you. And child support at this time is $1,836 per month, starting May 1st, 2022. Is that correct?
Yes.
And with the appropriate step downs, which are in the mediated settlement agreement. Is that correct?
Yes.
And you are to maintain health insurance coverage and dental coverage for the kids. Is that correct?
Yes.
And he is to reimburse you the premium. Is that correct?
Yes.
And anything not covered is 50-50 of the parties. Is that correct?
Yes.
And the marital home located 1560 Lion Lake Drive North in Westco is to be sold. Is that correct?
Yes.
And is to be sold at the no less than the appraised value. Is that correct?
Yes.
The net proceeds are to be divided. Is that correct? 50-50. Is that correct?
Yes.
Except on his half of the 50%, he'll pay any and all debts on the property and any and all obligation owing to My Fresh Start. Is that correct?
Yes.
And whatever property you have in your possession be awarded to you. Is that correct?
Yes.
And whatever stuff he has be awarded to him. Is that correct?
Yes.
Whatever bank accounts, retirement, whatever bank accounts that he has under his name be awarded to him. Is that correct?
Yes.
Likewise, whatever accounts you have under your name be awarded to you. Is that correct?
Yes.
And you're aware any and all retirement, IRA, 401k, any deferred compensation accounts under your name be awarded to you. Is that correct?
Yes.
Likewise, whatever retirement accounts that Mr. Nittler has, IRA accounts, thrift savings plans, any deferred compensation accounts, under his name be awarded to him. Is that correct?
Yes.
And each of you are responsible for any and all debts, so any property awarded to you all after that has occurred after April 15th. Is that correct?
Yes.
That is your agreement. Am I correct, Ms. Nittler?
Yes.
All right. And you asked the court to approve it?
I'm sorry, can you please repeat that last bit?
You asked the court to approve it.
Yes.
All right, Ms. Nittler, I don't mean to embarrass you with this question, but I have to ask it. You're not expecting or not pregnant
Sure.
this time. Is that correct?
That is correct.
Thank you. I have nothing further, Judge.
Okay, so we were able to get this done for final then?
This is for final, Judge. Yes, we settled all issues for final. Not for decree.
Okay, then the court is accepting the agreement as testified to on the record and as per the agreed settlement agreement, that was done in mediation. It'll be set forth in further detail in a divorce decree to be signed by the parties and by you, Ms. Reynosa.
Yes.
I didn't catch, was Ms. Nittler requesting a name change?
No, forgive me, Ms. Nittler, are you asking for a name change? I apologize.
No, I'm not.
Thank you.
Okay, so I'll go ahead and give you, I'll set a tickler for May the 13th.
Yes,
Just
Judge.
to see that it's been submitted.
Thank you, Judge.
Okay, best wishes to you, Ms. Nittler. You take care.
Thank you. I appreciate it.
Thank
Okay,
you.
anything else, Ms. Reynosa?
No, ma'am. Thank you. Might be excused, Judge.
You certainly may.
Thank you.
Okay, Mr. Salinas, I believe Mr. Munoz is on, so let me go ahead and recall your case. F5397-19-9 in the matter of the marriage of Esteban, Esteban Osuna versus Maria Luisa Osuna.
Yes, Your Honor, can you hear me?
Yes, I can, sir.
Yes, Your Honor. I've submitted already just a status hearing, Your Honor, and it's contested matter. I spoke with Mr. Munoz. You asked us to try to get that transcript, and neither him or I were able to get that. Is that correct, Mr. Munoz?
Judge, I'm here on behalf of Ms. Osuna, Your Honor. I think last time we were here in court, the issue had come up about a temporary orders hearing that was done sometime back. I guess after that hearing, Judge, I did contact the court reporter at the time in court 2, which was Mr. Al Flores. I sent him an email on March the 10th. I didn't get a response. I sent him an email on March the 17th. He didn't give me a response. I did notice that in March, Mr. Salinas said, well, the court reporter then responded to me telling me he did not have a transcript of the hearing that day. But then Mr. Salinas ended up emailing him as well, requesting it. And he responded to Mr. Salinas saying he did have a copy of the transcript. So needless to say, the response I have from Mr. Al Flores to Mr. Salinas on April the 17th was that he did have the transcript and he was requesting $100, I guess, so that way it could be obtained. So I guess the answer to the court is there is a transcript, from that temporary orders hearing, which I think was contingent a lot on what we were trying to, or what Mr. Salinas is trying to do now, I guess, in the next contested hearing. So I think we just need to now get that transcript so that way we'll have it for the hearing at the appropriate time.
Okay, Mr. Salinas, was there an issue of you ordering it once you were told that there was a transcript? Because I thought we had agreed that it would be paid out of the joint account.
Yes, but I didn't I don't believe I received that, Your Honor. But if I may, Your Honor, this is contested with the court because I think you are not obliged really to do temporary orders. If we can do a final hearing, is Mr. Munoz ready for a final hearing? Is your side ready?
Okay, well, this is what I said the last time, and I'm going to reiterate it again. I'm not obliged to do temporary orders. You can go ahead and go to final. However, when temporary orders exist, I cannot ignore them. So if
Yes.
there was temporary orders in a previous court, I need to know what they are because you all never put it into writing. So procedurally, the proper thing to do is for you all to order that transcript, get that order done so I can see it, and you all turn that in. And I don't know, I mean, you all are the only ones that can tell if you're ready for final. But if you're ready for final, or even if you're ready for final, doesn't mean that you're going to have an agreement for final. Ready for final means that you're ready, you have all the evidence that you need, all discovery has been exchanged so that you can argue whatever position it is that you all have. And if that's going to be the case, that's fine. Just file an order for DCC. If you all are saying that you want a bench trial, obviously you're going to get on the docket a lot sooner, and we'll go ahead and have a DCC conducted and we'll get you set. But in the meantime, you all also need to get that transcript because those temporary orders have to be done. They can't be ignored. So, I mean, I don't have an issue having set you up for a DCC. If y'all want to file an order for a DCC, you all can conduct the DCC, get the bench trial date, and in the meantime, between now and then, you continue to, you know, you're going to have to abide by the rules. So you'll have to exchange discovery, whatever's not exchanged in time, y'all know cannot be used, and get that transcript to so that you can have that order done. That's procedurally what we need to do.
Okay, Your Honor.
No, I understand, Judge. And I'll, like I said, I think for whatever reason why the court reporter told me otherwise, but needless to say, there is a transcript which I think would benefit all parties, including the court. And we'll go ahead and follow up and obtain that. And of course, you know, provide that information to Salinas and then do the order for DCC. But at the very least, we know that maybe what's on that transcript or that hearing that day could also be helpful.
Yeah, and you all are going to need it. And plus, if there's temporary orders and there's a transcript, I mean, you all both know you owe a duty to your clients to have that memorialized and submitted to them as well. So, and because you never know, like, I don't know when the bench trial is going to be. So you never know if you're going to have to modify those temporary orders, or perhaps you all have been operating under something that wasn't even ordered. You know, you never know if you're doing it to, if your clients are being overly accommodating without realizing it, or not accommodating and violating the order. Neither one of you can enforce it at this point until you memorialize it. So, I mean, go ahead and get your order for DCC done. You'll conduct that. In the meantime, just continue to get that transcript done. And if you want that transcript, I would definitely, you know, when you know it has to mirror, the order needs to mirror the transcript. And if your clients both testified, they don't have to sign it. But I am going to ask you in this case to attach the transcript as an exhibit to that temporary orders, because I need to see what happened.
Yes, Judge.
Okay.
Yes, Your Honor.
All right. If nothing else, gentlemen, then you may be excused, and the next time it'll be at the bench trial.
Thank you, Judge.
Thank you.
All right. Okay, Mr. Perez, I believe you have a pro se divorcer. Is that correct?
Yes, Your Honor.
Okay, and is Miss Perez getting on?
No, she won't be.
Okay, let me go ahead and look up your case. So you all do not have any children, is that correct?
No, we do not.
And you do not have any community property together, is that correct?
So we have it's kind of complicated. She has a vehicle that we bought brand new in 2019. It is under my name, the lien that it has, it's under my name. And then I have a vehicle as well that the lien is under both of our names. But she has agreed to keep on with the payments. She's been paying that car nonstop ever since we got it. And She says that she's gonna get a loan to take it out of my name, but she has yet to do that. It's already been 2 years since we've been separated. I'm just waiting for her to get it out of my name already.
Okay, so if she defaults on the loan, or something, what is gonna be your backup plan?
Probably go take it from her and sell it to the dealership. I don't know. I have no idea what I'm gonna do.
Okay, so that, I see that she didn't sign the divorce decree. I don't have an issue because really all you have are the vehicles and they're, you know, they're titled already. Those are called titled things, right? So like in that case, the only thing I'm gonna do is just put that, because remember, you also have a vehicle that's under your name and her name. So if you default, she can also come and get the vehicle for yours as well.
I'm in the process of selling it so that it gets out of
Okay.
both of our names.
So I'm just gonna, the only thing I'm gonna add to that decree is just to say that, okay, that you can, if she defaults, you can pick it up, and if you default, she can pick it up. Just so
Alright.
it's, like we say, even Steven, okay? All right, go ahead and raise your right hand, Mr. Perez. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You may lower your hand. State your full name for the record.
Jose David Perez.
And you're currently married to Kimberly Perez, is that correct?
Yes, I am, Your Honor.
And you do not have any children together, is that correct?
No, we do not.
And she signed a waiver, is that correct?
She did.
Okay, and you lived in the county for at least 90 days and in Texas for at least 6 months at the time that you filed for divorce?
Yes.
And you were married on or about November 21st, 2016, and you ceased to live together as husband and wife on May 10th, 2020, is that correct?
Yes.
And you're asking the court for a divorce today because your marriage has become insupportable due to discord or conflict of personalities.
Yes.
Is that correct? Is there any chance for you to reconcile?
No.
Okay. And is your wife currently expecting a child of this marriage?
Not to my knowledge.
Okay. Is she currently expecting a child of any relationship?
I believe she's been living with her boyfriend for pretty much ever since we split up, and he has 2 kids of his own.
But is she pregnant with his child?
No, not to my knowledge.
Okay. So is she requesting a name change?
No, she said that she wanted to do it on her own over there in California.
I understand. Okay, so you and the only community property that you and your wife have are the vehicles, is that correct?
Yes.
Okay, and so any community property debt, any debts that are solely under your name, you will be responsible for, and any debts that are under her name, she will be responsible for, is that correct?
We came to the agreement that because the vehicle that is in her possession right now is under my name, but she will be taking those payments. She's in charge of paying that.
Okay, and I'm gonna get to that right now.
Oh, okay.
So the 2022 Dodge Ram is under whose name?
Mine.
Solely under yours or yours and hers?
Mine, just mine.
Okay, and you will be keeping that vehicle along with the debt, is that correct?
Yes.
And the 2007 Chevrolet Silverado is under whose name?
Mine and hers.
Okay, and so that vehicle, does it have any debt?
Yes,
Okay, and you will be continuing to pay that debt?
I will.
Okay, and you understand if you default, she has a right to come and get that vehicle?
She does, yes.
Okay, and so she will be keeping the 2019 Volkswagen Jetta, is that correct?
Yes.
And she's going to be paying that debt as well, is that correct?
Yes.
And that vehicle is under your name, correct?
Yes.
And if she defaults on that vehicle, then you will be picking up that vehicle, is that correct?
Yes.
Okay. And so you're asking the court for a divorce today?
Yes.
Okay, then I'm granting the divorce as testified to on the record set forth in a divorce decree that has been filed on May 2nd, 2022. That's the one I'm going to ask that it be forwarded to my queue. And that's the one that I'll go ahead and write in there that she can pick up and you can pick up as well, okay?
Alrighty. So
All right,
I'm
so
gonna get a
anything else?
paper. Will I be getting paperwork or something in the email or
Yes, as soon as I sign the decree, you will receive it in an email.
already? Yep. That
Okay,
sounds
so
good.
your divorce decree will be, your divorce will be final 30 days after I sign your divorce decree. Okay, if you want to get married before that time, you will require a waiver from the clerk's office.
Alrighty.
Okay,
That's all.
all right,
Yes.
best of luck to you, sir.
Thank you. Maybe I was excused.
You certainly may, sir.
Thank you.
Mr. J.R. Garza, what do you have, sir?
Good morning, Judge. I think it's still morning, right?
Yes, for about 35 more minutes.
I'm here on F 345329, Judge, in the matter of the marriage of Omar Daniel Villanueva and Perla Villanueva.
Okay,
And we set for final hearing, Judge. There was an order setting hearing. So evidently, Judge, just so you can know, I think that the respondent made an appearance in one of these Zoom hearings. And so we went to, Your Honor had ordered us to go to mediation with Melinda Diaz. She refused to go to mediation. We ended up going to an informal mediation. We resolved most of the case, most of the issues, except that we didn't really resolve anything because she didn't sign it, because she didn't want to do the step down on the child support. So
Right.
Today, Your Honor, I think we're ready for a post-divorce, rather a post general appearance default. She's not present today.
okay, and is your client present?
He is, Your Honor.
Okay, let me just check. Ms. Rivera, can you make sure that Ms. Villanueva received notice of today's hearing?
What I will tell Your Honor is I have an order setting hearing in my possession right now that was filed on 4/4/2022.
Okay.
Where there's a copy at the very bottom of that. It's signed by Your Honor, and at the very bottom, it has Perla Villanueva, her email and her address as well. So
Your Honor, that is correct. It was sent to her address and her email.
Okay, all right, then Mr. Villanueva, can you please raise your right hand? Okay, I'm sorry, can you go ahead and unmute, sir, first? There's a little microphone at the bottom.
Can you hear me?
I can, sir. Okay, raise your right hand. Do you swear that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, lower your hand and just listen to the questions carefully that your attorney is going to ask. Go ahead, Mr. Garza.
Sir, will you please state your full name for the record?
Omar Daniel Villanueva.
And you're the same Omar Daniel Villanueva that filed an original petition for divorce under F 345321, is that correct?
Yes, sir.
You're married to Perla Villanueva on or about December 27th, 2000, is that correct?
Yes, sir.
And you ceased to live together on November 1st, 2018?
Yes.
Is that correct? And you have been in domiciled in Hidalgo County for the last, Hidalgo County, Texas for the last 6 months, is that correct?
Yes, sir.
And you're here because you're asking for a divorce, is that correct?
Yes, sir.
And has your marriage become insupportable because of discord and conflict of personality, that it has destroyed the legitimate ends of the marriage, is that correct?
Yes, sir.
Okay, I'm sorry, Mr. Garza, to interrupt. My staff is notifying me that the link was not sent to Ms. Villanueva. No, she had notice of today's hearing, but she was not given the link for today.
Okay, just what do you?
I'm gonna give her notice of the link so that nobody says that she was provided notice of the date and time of the hearing, but she was not provided a way to get onto the hearing. So what I'm gonna do is I'm gonna go ahead and reset you for next Monday
Okay.
at 9:30, so that the link is given to her. And if she still doesn't show up, we'll proceed. And even if she does show up, a step down is something that is required, like I told her said the last time, by the statute. So you're just following the statute. I'm not gonna have an issue with whatever it is that you calculated ordering it.
Thank you, Judge. Oh, by the
I
way.
apologize, Mr. Villanueva. I'm not sure why the link wasn't sent out. I don't know if we even had her correct email address. So, but we will get that. So hopefully by next Monday, we can finalize it for you, sir.
Okay, that's the 9th, is that correct, Judge?
At 9:30.
The 9th at 9:30.
Yes.
Thank you, Judge, very much.
Okay.
Thank you.
All right. Thank you, sir.
May we be excused, Your Honor?
Yes.
Thank you.
Okay, so Mr. Sanchez, your case was called for, are you here on Skylar? Patrick Sanchez?
Yes, ma'am.
Okay, your attorney asked for the case to be retained on the docket. And so you're set for a status hearing on June the 6th at 9:30. Mr. Villalobos, if you want to contact Mr. Villalobos or Mr. Gutierrez.
Ma'am, we were kind of thrown off guard. That's why we hadn't said anything earlier, but we wanted to come back on. There is a safety issue with Skylar with where she's living right now. We were honestly hoping this was going to be our last court hearing about this because it's been pushed back 3 times.
Yes, well, unfortunately, nobody has showed up the last couple of times. So I didn't have a choice but to have a dismissal on it. Your attorneys requested that it stay on. And so you'll have to talk to them about that. As of right now, you'll have a setting for June 6th at 9:30.
Well, I just wanted to add also that we just found out last week that she moved to her grandma's and her uncle is living there, which is also a unregistered sex offender.
Sir, that's information that you have to give your attorney's office. I mean, and so you need to let them know, and they'll file the appropriate paperwork.
Okay, because honestly, it's been a little difficult to contact our attorney. Even today, we didn't know he wasn't going to be available and it was going to be somebody else. And we were trying to talk to him before and just to end up finding out that he was just going to push it back.
Yeah, I don't know what to tell you except that you'll need to contact them because I can't talk to you about the case.
Okay.
Okay. But I did give you a setting. So your next setting is June the 6th at 9:30.
Okay, thank you.
Okay. All right, thank you. Okay, who do I have on the phone with the last 919? If you can unmute.
Good morning. Good morning, Your Honor. It's Stella Olivares.
I need to memorize your number, Miss Stella.
That's okay, Judge. You have so much work.
Okay, that's on F2822-16-9 in the matter of the marriage of Miriam, M-A-R-I-A-M, Millen, M-I-L-L-A-N hyphen Martinez, and Hector Miranda.
Yes, Your Honor. Stella Olivares, Your Honor, it's just a non-pro-tongue. On the language on the arrears and the insurance arrears and the medical, and the Attorney General sent me the language they needed. So that's why I'm correcting that. It's the same amount, but in the non-pro-tongue, I split the 2 judgments.
Okay,
so that's all I have.
Okay, go ahead and get that amended and submit it to us by May the 13th if you can.
Yes, and I believe it's already e-filed, Judge. I'll check with my
then I'll
staff,
ask.
but we did e-file it.
Okay, I'll ask for it to be forwarded to my queue, so that motion is granted.
Thank you, Your Honor. You have a wonderful day.
Thank you, you too. Take care. Okay, let me go ahead and go back through the docket. Let me call number 12 on the court's docket, CL144509-I, Allstate Insurance versus Iris Trevino et al. Did anybody call in on that?
No, Judge, and there's no Rule 11 or order resetting.
Okay, please set that on the next drop docket. Number 15, CL190744-I, Discover Bank versus Deborah, D-E-B-O-R-A Cano. Did anybody call in?
No, ma'am, and there is no Rule 11 or order resetting, Judge.
Okay, thank you. Please set that on the drop docket. All right, on number 24, did they file a Rule 11 or were they going to re-urge their special exceptions?
Judge, on number 24, there was a Rule 11. There is no order resetting. In the Rule 11, there's language stating that there's going to be, they're going to amend their petition if I'm not mistaken.
Okay, that's fine. Okay, let's set them up. When was there, let me go ahead and go back and look to see if they've had a status hearing. I'm sure. Okay, it's been a while since they had let's go ahead and set them for a status hearing on June the 27th. Let them know. I just want to know where it's going.
Yes, ma'am.
Okay, that takes care of this morning's docket. We are now